Holy guacamole. This is so many documents we've got to catch up on. Let's get started. Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only, and just like everything else in these cases we discuss here on this channel, everything is alleged. Okay, the last time I uploaded anything when it came to a document in the Idaho 4 case, it was the defense's 15th supplemental request for discovery. Now, there's a lot going on. There doesn't seem to be a lot going on, but there is actually a super lot going on. Today is April the 2nd, and we have a hearing coming up in 2 days. On Thursday, April 4th, is the next hearing in the Idaho 4 case. So before we get to that, before we get to Thursday and all kinds of new crap gets stirred up, let's go ahead and go through the latest documents and see what's expected. Okay, so 3/29/2024, we have the declaration in response to defendant's motion to rescind order. Now, this is from the state. It states, "Come now, the undersigned prosecuting attorney for Latah County, Idaho, and as an officer of the court, declares and represents the following in response to defendant's motion to rescind order for failure to provide due process filed on March 26th of 2024. We did go through that entire document in the last video. It looks like this. If you guys need to go and get caught up, I do have an entire playlist. We've gone over every single document that's ever dropped publicly in this case, and a few that weren't so public. It goes on to state that on March 8th of 2024, our office received information from a Latah County resident who received an unsolicited telephone survey regarding the Kohberger case. Our office promptly forwarded that information to the Moscow Police Department for follow-up investigation to interview the person who received the call, ascertain the nature of the call, and determine who was responsible for the call." So instead of just asking those questions themselves to the person who reported the call, they had the cops go out there and do it like it was a criminal investigation. Come on now. Several days later, our office received additional information that another Latah County resident was contacted by a telephone survey company. Our office forwarded that information to the Moscow Police Department to be included in its follow-up investigation. Again, sending information that they are getting personally from the residents to the police instead of just asking, "Hey, who called you? What did they say their name was? Do you happen to have the number? Do you mind sending me a screenshot of your call log that shows the date and the time that they called?" All of that could have been done by their office. I don't know why they're sending the cops out to do this. Whatever. On March the 12th and March 19th of 2024, Moscow Police Department Corporal Brett Payne, of course it's Payne, provided our office with the results of the investigation into this matter, which consisted of supplemental reports 260 and 262, attached to the state's March 22, 2024 motion for order prohibiting contact with prospective jurors absent leave of court, which of course we're not privy to because everything is sealed. During the time between the initial information being received by our office, March 8th, and receipt of Corporal Payne's supplemental reports, March 12th and 19th, our office became aware of two other individuals who received similar unsolicited telephone survey calls. One of those individuals recorded the call and provided a copy of that recording to our office, which was then transcribed by our office and attached to the state's March 22nd, 2024 motion for order prohibiting contact with prospective jurors absent leave of court as Exhibit B. And see, I questioned how they got that. I questioned, how do they have a transcription of the call? Did somebody make the call from the courthouse themselves and they were able to just get it because it was on there somehow? Or did one of these residents record it? Now I have my answer. The other individual provided a one-page written summary, which was attached to the state's motion as Exhibit C. It was suspected that the unsolicited telephone survey calls were being made at the request of or on behalf of the defense. On March 19th of 2024, Senior Deputy Prosecutor Ashley Jennings reached out to Ann Taylor and inquired whether she was aware of the phone surveys being conducted with Latah County residents. Ms. Taylor affirmed that she was aware and offered to meet with our office to discuss the afternoon of Thursday, March 22nd, 2024, when she was going to be in Moscow. So she doesn't live there? What's she be doing? On March 21st of 2024, the undersigned met with Miss Taylor, defense investigator Rich Batanti. Oh, he's still working the case. Well, that's kind of interesting. And Senior Deputy Prosecutor Jennings. During that meeting, Ms. Jennings and I were told that the survey calls were being made on behalf of the defense. We expressed concerns to Ms. Taylor regarding the nature of the calls and the fact that the calls were affirmatively sharing purportedly factual statements as reflected in the state's motion for order prohibiting contact with prospective jurors absent leave of court and its attachments. We explained our concerns regarding contacting potential jurors and planting purported facts in the minds of those potential jurors who may not have heard those purported facts previously. This is particularly disconcerting because some of the facts referred to in the phone surveys are not true and consequently would create a false impression or understanding with those Latah County residents and potential jurors. We talked about this. I said this. I found it really not okay that I don't care about the defense doing the survey. It was never something that I had heard of before, but in the comments of that video, I asked if you'd heard of this before, if you've received this sort of like survey before, let me know down in the comments. And it's not too uncommon, but my big problem, and again, we talked about this in the video where we went over those documents being mentioned here. The defense is even putting in their own documents that the survey questions are full of non-facts because it wants to see how the residents are going to react to these like crazy social media type facts is the way that they put it. They said that that's the whole point. The information being incorrect is the whole point because they wanted to see how they were going to react. I've had an issue with that since I heard that. Like giving facts that we know from like the exhibits for the PCA is one thing. Going based off of something that we already know as the public as an actual fact of the case is something else. But whenever they're sitting there and they're calling people that are potential jurors and they're giving them false information from an official source, okay, an official source meaning this company that apparently has a long-standing reputation for doing things like this. It's a doctor that put the surveys together based off of media and social media. And basically what I believe he probably did, because it's 2024, is he took like some sort of AI programming and had it like create a survey based off of all of the Idaho 4 conspiracy theories is basically what I believe, in my opinion, this person did. Okay. Now there's probably an old school way of doing it, but all of this change of venue stuff, literally, like I know that it's been discussed as possibilities, but it just became more of like a reality over the probably last like what, 45 to 60 days, probably not even that long. So for them to go through all of the social media stuff, you know how many people on a team they would have to have in order to go through all of the crazy conspiracy theories in the Idaho 4 case? Because this isn't just on YouTube. There's stuff in the Reddit forums that nobody on YouTube has ever talked about. There's stuff in the Twitter spaces that no one on YouTube has talked about and no one on Reddit has talked about. Then we have the Facebook pages and then we have TikTok, okay? Then there's all these other websites that some of us don't even know about. All right. So I don't know how, without some sort of AI program and the timing that we're hearing, they did this so quickly with it being like non-facts just to get a reaction out of people. I never agreed with that because this source isn't then, from what I'm understanding by the anger of the state, isn't going back in and being like, hey, did you know? And this is the example that I used last time. So pay attention to the fact, some of you, okay? Pay attention to the fact this is an example, okay? Say the survey said, are you aware that one of the facts of the case is that Bryan Kohberger's DNA was found under Xana Kernodle's fingernails? Okay. Well, at this point, the only DNA they're telling us even exists when it comes to anything useful is on that knife sheath, not under any of the 40 fingernails or any of the 40 toenails or any of the teeth or any of the anything. Okay. They've never once, I'm just going to put it like this. If there was DNA under the victim's fingernails that matched Bryan Kohberger, If there was DNA from him anywhere on any of their bodies, they would be using that. They wouldn't be using touch DNA that can easily be explained away or could have magically gotten there without him ever being in that house, because that's just the truth. If they had something stronger, they would have used it. They would have, okay? They just would have. So whenever those survey questions are saying stuff like that, but then not saying, by the way, that's not a true fact of the case. That's just a conspiracy theory. That's just something that was created online. It's not real. That's tainting the jury pool. That's tainting the jury pool with a bunch of cockamamie bullshit ideas, and you're not taking any responsibility or accountability for what you've now done to how many people? 400 was on that list, right? Could have sworn that's what I read in the last document. But that's not okay. And now we have 4 people contacting the courts and being like, what the hell is this? What in the shit is this? For there to be 4 people outraged enough by the survey to contact the courthouse, I hope we get like some sort of idea about what the questions were like, because I'm pretty positive that's what triggered so many people calling it in. It had to have been just like completely outlandish stuff. Who knows? We told Ms. Taylor that our office felt this information needed to be brought to the court's attention. We proposed sending a letter to the court and attaching copies of the information received with copies to the defense. Ms. Taylor expressed concern regarding this procedure, indicating that she would want to respond to the information prior to the court ruling on the matter. I mean, yeah, it was supposed to be like a meeting of all 3 of them. It was supposed to be both sides and the court. But then the state did something different, which is why, Anne got all mad about it. We then discussed an alternative method by filing a motion with the court with the same attachments. Ms. Taylor again expressed concern with our office providing the court with anything before an actual hearing. We explained that a motion with supporting documentation is standard practice, and that is the route we would be taking. Following our meeting with Ms. Taylor, we consulted with our attorney staff and decided to proceed with filing a motion with attachments. That motion was prepared and filed shortly before 2:30 p.m. on the following day, Friday, March 22nd, 2024. The state submits this declaration in order to clarify for the record what was occurred in relation to the unsolicited phone calls being placed to Latah County residents and to correct certain representations contained in the defendant's March 22nd, 2024 motion to rescind order for failure to provide due process. Basically claiming, yeah, we talked about it. Yeah, we were supposed to wait and all talk together, but we then talked in private and we decided that we didn't like what was happening and we didn't want to give them a chance to try to make an excuse and not get in trouble for this. So even though we agreed to do one thing, we turned around and did something completely different because we do what we want, is basically how this reads to me. Which again, depending on the questions and what was actually being told to the residents, if this is such a common thing, then what are you worried about? Why are y'all acting all crazy about something that's common practice? And by the way, done by this doctor before in Idaho. This is not like the first time he's done this exact same thing in this state. He's done this a few times before, and it's never been a problem. So I don't know why suddenly it's a problem here. Again, unless the questions that were being said to the residents were just completely asinine. Next, it shows we have this motion to unseal state's motion for order prohibiting contact. So they want to unseal the motion for prohibiting contact, which hopefully would mean that we would get the information from the residents, because it was attached to these, including the transcription. That'd be interesting. Comes now the state of Idaho by and through the Latah County prosecuting attorney and respectfully requests that the court enter an order unsealing the state's motion for order prohibiting contact with prospective jurors absent leave of court, filed herein on March 22nd, 2024, but keeping the attachment sealed, to protect the identity of certain county residents and to avoid violating the court's non-dissemination order. Hold up. You could easily release those redacted without the person's name. These literally could be released with information protected, and it wouldn't be a problem. I don't know why they act like redactions don't exist. It's so stupid. In support of this motion, the state respectfully represents to the court as follows. The state asks that its original motion for order prohibiting contact with prospective jurors absent leave of court be filed under seal pursuant to Idaho Court Administrative Rule 32 for the reason that the attachments to the motion identify certain Latah County residents who have received unsolicited telephone survey calls regarding this case, and the state felt it was appropriate to protect the identity of those individuals. Again, redactions exist. All of the public, like how many public documents that are out here, search warrants and all of the things, have redactions. Like, come on. The state was also concerned that the nature of the unsolicited telephone survey contacts contained information that could violate the court's non-dissemination order, including information that is factually false. Okay, so that actually makes more sense. They don't want to release a transcript because it could possibly, because of what they already know is in it, which actually kind of makes me wonder if there's some facts that maybe the public just doesn't know about, and maybe that's what the state's getting all their, panties in a twist about. Maybe that's why they won't release a transcript. Subsequent to the state filing its motion under seal, an interim order was issued by the court properly prohibiting the parties from contacting prospective jurors, at least until the state's motion for order prohibiting contact with prospective jurors absent leave of court was heard and decided. Following the issuance of that order, which did not contain any information that would violate the non-dissemination order, nor any factual information that was untrue, the defense filed a motion to rescind order for failure to provide due process on March 26, 2024. The motion contains representations that are either inaccurate or misleading as to events leading up to the state's March 22nd, 2024 motion for order prohibiting contact with prospective jurors absent leave of court, meaning they're claiming that the series of events that we read in the last video, what the defense put out here, those sequence of events, according to the state, are inaccurate on the defense's part. Okay. Unfortunately, the defendant's March 26 motion was not filed under seal, so anyone reading the defendant's motion, whether private citizen or media, will have erroneous or incomplete understandings of the circumstances leading up to the state's motion. Okay, but the only thing that was in what we read in the last video was all of these dates that they're talking about again now. It's just the defense giving them to us. About when the survey started, when the state knew, when they talked about meeting all together with the court, what they ended up filing. I haven't heard, again, I'm not like comparing the two. There could be a couple days off or whatever. I'm going to go back and do some comparisons now that they're sitting here complaining. But so far, it all sounds the same. It all sounds the same to me, so I don't know what they're talking about. Based on the above, it is proper and necessary that the state's March 22nd, 2024 motion for order prohibiting contact with prospective jurors absent leave of court be unsealed so that the publicly available record in this case more completely and accurately describes the relevant circumstances and events, provided, however, that the attachments remain sealed so as to protect the identity of the named citizens who provided information in regard to the unsolicited telephone surveys and to avoid any further violation of the non-dissemination order. So is that what we just read? Actually, it sounds like that's actually what we just read. Okay, we'll figure all of that out. The next one is objection to defendant's motion to rescind the order. Now, they put that one, when did they put this one in here? 326, that's this one right here. This is the one we went over before, the motion to rescind order for failure to provide due process. And now this is going to be the state's objection to that. The state objects to defendant's motion challenging this court order prohibiting further contact with prospective jurors, which was entered after the state filed a motion and the defendant filed an objection. Defendants claim that this court failed to provide due process is belied by both the applicable law and the facts surrounding this court's order. Defendant's factual recitation in support of this motion leaves much to be desired, leaving out critical facts that are fatal to his argument. See, that's them again claiming that the defense is not giving the most accurate series of events when it comes to what happened here. Most glaringly, defendant fails even to mention this court's revised amended non-dissemination order, which this court entered more than 6 months ago after briefing by the parties and oral arguments. As relevant here, the non-dissemination order, or the gag order, prohibits certain out-of-court statements, including out-of-court statements that relate to the identity or nature of evidence expected to be presented at trial or any sentencing phase of the proceedings. Now, see, that again is just making me think that in this transcription, there's some for real facts that are being asked that they don't want out there. That's what this is making me think. On March 8th of 2024, more than 6 months after this court entered the non-dissemination order, the state received information from a Latah County resident who received an unsolicited telephone survey regarding this case. I'm going to go ahead and assume there's going to be a lot of repetition in this from what we already read. Okay, not my fault. I didn't write it. The state had little information about the call at the point and did not yet have reason to believe the defense had violated the non-dissemination order. By March 19th, however, the state had learned that multiple other Latah County residents had been called and learned the callers were disclosing information about evidence that would be presented at trial. That would be presented at trial. I'm trying to just like make sure that I'm right, because sometimes whenever I'm right, my brain gets a little fumbled and I want to make sure I'm reading this right. Learned the callers were disclosing information about evidence that would be presented at trial. They're giving them real for real factual case evidence questions in these damn surveys. But then again, if the transcription is never actually released, and how are we supposed to know that? They could literally just be arguing that to make that the argument and it not really be true, because the defense is claiming, oh, we're just asking like social media bullshit questions, things that are found up on the internet to see how people react to stuff. Oh, which one's telling the truth? Which one is being honest? But this is also going back to the point that the defense stated that the state knew about all of this already, and they didn't really quite understand, according to them, why all of a sudden, after knowing for so long, after a few weeks of knowing, they suddenly had an issue. And it was only because they ended up getting, 3 additional residents giving them information, including a recorded call. So, equipped with this new information, the state had serious concerns that the defense was violating the non-dissemination order, and giving the defense the benefit of the doubt, decided to contact defense counsel prior to raising the issue with the court, which is what we heard earlier. The defense confirmed that the calls were being made on their behalf, and the state expressed its concerns regarding the calls and informed the defense that the issue needed to be raised with the court. The state filed a motion seeking an order prohibiting further contact with the prospective jurors, and asserted as the sole legal basis for its motion that the contact violated the non-dissemination order. And that's only because they're giving real facts, guys. They can only claim that if they are literally giving out really, truly factual case facts, which is the opposite of what Ann Taylor is claiming in the last document we went over in the last video. Defendant filed an objection the same day that conceded the defense had conducted such a survey and indicated that a memorandum in support and affidavit were forthcoming. The court then entered an order prohibiting either party from contacting prospective jurors. The order states the court had reviewed the materials submitted by both parties and that a hearing on the issue will be held as soon as practicable, which is what's happening Thursday. The court has now scheduled a hearing for April 4th of 2024, less than 2 weeks after entering the order prohibiting contact. So get ready, because hopefully it's public. Hopefully it's a live session. Hopefully we see all of the things. I doubt it, but one can hope. This further explanation of the facts demonstrates that this court has provided defendant due process. Due process is satisfied when the defendant is provided with notice and an opportunity to be heard. But I can understand, okay, how Ann Taylor is claiming, no, you didn't, because you said that we were going to go and have a hearing about this in front of the court, not a hearing, but that they were willing to meet in chambers with the state and the judge to talk about the situation in front of the court, to come to some sort of resolution or agreement or negotiation before any of this became an official filing. They talked about it and agreed to that, and then decided to go behind the defense's back and file this stuff anyway with no heads up to the defense that they were going to go ahead and do the filing. That's what Ann Taylor's issue is. Yet, it is not a concept to be applied rigidly in every matter. Due process is a flexible concept calling for such procedural protections as are warranted by the particular situation. Due process is a flexible concept? How is due process a flexible concept? They're going to have to explain that one some more. The court has complied with due process on this issue by providing defendant notice and an opportunity to be heard at every stage related to attorney contact with the public. Early in this case, defendant stipulated that a non-dissemination order be issued to protect against adversely affecting the integrity of the case to be presented at trial. This is true. Bryan Kohberger's team also agreed with the gag order, and the defendant briefed and argued in favor of the non-dissemination order. Yes, this is true. The state's recent motion asserted as its sole legal basis that the defense may have violated the non-dissemination order by including certain questions in the jury survey that disclosed information about the case, and the defense's objection filed prior to the court entering its order conceded that the defense conducted the survey. Again, that only can happen if really truly factual information is being given out. In light of that information, this court's subsequent decision to prohibit any additional contact with prospective jurors, at least until further order of court, allow for defendant to provide an affidavit and memorandum in support of the objection and quickly schedule a hearing at which defendant can be heard, plainly protected defendant's right to due process as warranted by the particular situation. Conclusion: this court should deny defendant's motion for the reasons stated above. Dang. Okay. Next document. This one is the reply in support of motion for order prohibiting contact. This one seems to have been submitted by the state. Okay. The state submits this reply to address two major flaws in defendant's memorandum in support of his objection. This is most likely going to be them explaining what they meant in the last document about how, because the defense didn't file their information under seal, that the public now has seen information that they're claiming isn't true. So this seems to be them correcting what they're claiming to not be accurate. Okay. First, defendant's explanation of how the survey complies with the non-dissemination order does not withstand even the slightest scrutiny. Defendant argues that hiring a professional firm to contact prospective jurors in Latah County and ask questions embedded with specific facts from the case, more proof that these are facts and not facts, the way that the defense originally is trying to claim they are, does not violate the non-dissemination order because the embedded facts were already disclosed by the media. But see, that's questionable too, because a lot of the crap that the media has put out here is stuff that there's no stance on. Like him following them on social media, we've talked about this, okay? We've talked about this. Even the companies that have interviewed the Goncalves family and talked to the Goncalves family about how they apparently have all these screenshots of this profile of Bryan Kohberger that was following the girls the second that they heard about the arrest. They ran and they found out because they knew they only had a very limited amount of time and they had to just check and see, and they have all this proof. Every single company, every single production company, every single news company, every single all of them, okay, that has talked to the Goncalves family, and that's part of the conversation, somewhere on the screen or somewhere after the conversation is over, they then come out and claim they have been unable to prove that any of it was true. So mainstream is sitting there telling you about all of this, but then telling you that they can't prove it to you. They're just going to keep telling you all this information that they have no proof of, that all of these companies have not seen a single shred of proof of. So if all of these companies have found no proof, but they keep on saying it, how is that not wrong? How is that not wrong? The hypocrisy is a bit much. But with respect to both attorneys and their agents, the non-dissemination order prohibits any out-of-court statement which a reasonable person would expect to be disseminated by means of public communication that relates to several categories of information, including the identity or nature of evidence, again, with this verbiage, of evidence expected to be presented at trial or any sentencing phase of the proceedings. They are doubling and tripling and quadrupling down on the fact that there is real case fact being given out in this survey. Defendant's interpretation that his attorneys and their agents can discuss with prospective jurors anything the media is already discussing would eviscerate the non-dissemination order. Would it? Would it? Because if the media is already talking about it and all these other people can be brought in to talk about it and they're just talking about the same thing that the media is talking about, then what's the problem? See, this is why I want the transcripts. I want to know the questions that are being asked, because how are we supposed to know which side is telling the truth and which one isn't? I mean, obviously, we're the public, it doesn't matter, but we just don't know if the true winner is the true winner or not. We're going to have to literally just be like, oh, the judge isn't going to fake it. The judge is going to make the right decision. Okay, well, the judge already very prematurely acted on this. Like literally instantly. The state filed what they filed and Judge was quick to sign it. So we've already kind of seen how that could go. Just saying. Nor can defendant credibly use as cover that the survey is asking questions rather than making statements. The mere fact that the identity or nature of evidence is being presented to the prospective jurors in the form of a question does not bring the survey into compliance with the non-dissemination order, meaning you might think you found a loophole, broski, but you did not find a loophole, broski. The specificity of the facts included in the questions implies to the prospective juror that there is something to see here. Undoubtedly, such questions would draw quick objections in the voir dire process. Defendant also badly asserts that the non-dissemination order expressly allows the conduct in which his attorneys and agents have engaged, but he fails to quote or even cite to the portion of the non-dissemination order he believes authorizes this conduct. The state's best guess is that the defendant is referencing paragraph 2 and subparagraph E, which allows the attorneys and their agents to request assistance from the public in obtaining evidence and information necessary to the state's case or the defendant's case. Clearly, however, that subparagraph is a reference to general request made to the public to obtain, not reveal, evidence or information about the case. For example, the attorneys or their agents could put out a statement indicating they are looking for any persons who were present as X location on Y date. Nothing in subparagraph E authorizes the attorneys and their agents to target prospective jurors and share with them specific facts about the case, meaning they could put out something saying, hey, I need to hear from anybody who might have been at a pool party at this apartment complex on this date. Please contact our office type situation. That doesn't do what this is doing, apparently. Okay. Second, much of the defendant's memorandum and the entirety of the affidavit submitted with the memorandum are an attack on an argument the state has not made. I'm not really quite sure what they're insinuating with that, because yes, you made an argument whenever you filed something late in the afternoon at the end of the work week after already telling the defense you weren't going to do anything until y'all all met together. So you technically started this attack, Thompson, okay? Let me continue because I'm not understanding that statement. The memorandum and affidavit go to great lengths to explain to this court that as a general matter, jury surveys are not inherently improper for the purposes of a change of venue motion, right? They are pretty common from what we're learning. The state has not taken a contrary position. And there is a footnote of number 1, and it says, the state questions the usefulness of such surveys, but the weight, if any, that should be given to the survey is not at issue here and will instead be addressed during the change of venue briefing, meaning the importance or what this might do to the case when it comes to the change of venue itself is not at question. This is literally the state having issue with the substance and subjects being asked because they're claiming it is true case fact that's going to be presented at trial. And if that is truly the case, if that is for real the case, then I kind of have to agree with the state on this. I kind of do. But then again, I want to hear it. I want to read the transcript. I want to know exactly what they're claiming is case fact, which is the problem, because they're not going to give us that. They're not. Okay, goes on to state, instead, the sole legal basis for the state's motion is that in this particular case, this court's non-dissemination order prohibits certain questions defendants' attorneys and agents chose to include in the survey. Exactly what I just said. Given the state's, this court's, and at least up until this point, defendants' agreement that the non-dissemination order plays a vital role in protecting the integrity of the trial, the state filed its motion to bring this matter to the court's attention. But again, you did so after already telling the defense that you wanted to get with them and meet in court together. You did something different than what you originally agreed on, and that is the problem. Okay, now these two look like they were just put in here out of order because this is a motion to temporarily seal an exhibit for the defense. It's 12 supplemental requests for discovery pending a hearing. This is not related to this at all. And then we also have this motion to file exhibit. You see how these dates are out of order? See, this one right here should be up here where these are. And then this motion to file exhibit should be in between these right here. Let's see what this one is. They just loaded wrong. They loaded differently. Motion to file exhibit M attached to the defendant's 14th supplemental. Okay, yeah, just more sealed exhibits. Has nothing to do with this current situation. Now, I'm going to go ahead and open this one. I already know what this is. This is for the Dr. Bryan Edelman, which is the doctor who has been doing these types of surveys and helping basically guide the flow of trials. This doctor works for a company that helps these things happen all the time. He's apparently been doing this for 20 years. This is them wanting Bryan Edelman to be able to be present on April 4th via Zoom. And the session is at 1:30. It says counsel has arranged for expert witness Bryan Edelman, PhD, to be available via Zoom on the date and time. So I don't know. I'm guessing that the judge is going to still have to sign off on this. Probably so, but I guess we shall see. Hey guys. Okay, so I recorded this video last night. It is actually April the 3rd right now. I went ahead at this point. I figured this would be a good segue into looking at the most recent documents to try to answer that previous question. So we do have a couple of more documents. So that's awesome because I was really hoping that by the time this long ass video was over, we would be completely up to date, and I would have been heartbroken if I would have posted this whole video and then checked this and saw 3 more documents. I would have just died. So this first one is the motion for this criminal hearing, which is what we have been reading in these past documents that was going to be happening tomorrow. Tomorrow is Thursday, April the 4th, and this was whenever this is supposed to be taking place. Now this is just showing that this is going to be taking place in the courtroom, so that means that everybody will be brought into the courtroom as normal. Now it looks like there was an original order permitting the Zoom participation of Dr. Edelman, but there's also an amended one. Okay, so this is the court having no objection to it. That's good because that's an expert witness. And if these surveys are so normal, then knowing that he's done this for 20 years, hearing what he has to say about it will be a good thing. Because again, if this is so normal, okay, is it really because of the gag order that the state has a problem? Or do they just not want to change the venue? Or what is it? Because if we have any indication whatsoever tomorrow about the type of questions that the state actually has issues with, then maybe we can make a better, have a better opinion of this, a more educated opinion of this anyway, because it's still just an opinion, okay? But I just don't understand
how severe it could really be whenever this doctor has done this for so long. It seems like he would know what would be okay in a case where there's a gag order. You know what I mean? Like, it seems like he would have known which questions would be appropriate and not violate the situation. I feel like 20 years, you would have that knowledge. Okay, so I just looked on Twitter and I looked at a couple different pages, a couple different profiles. I did some Googling. I don't know if this is going to be a live streamed session or not. Now, it seems like there's a few other YouTube creators that have like their notifications on to go live for the hearing. But I don't know if that's because it's actually going to go live or if that's because that's about the time they figure that it's going to be posted to, the news stations the way they normally do after the fact. They'll post something about it online or there'll be some information about it posted online. I don't know. I'm not going to sit here and act like I know. I have no idea. I can't find the information anywhere. So if I figure that out, I will drop it in the community post. But let me go back to yesterday's me so that we can get to Ann Taylor's response to all of this.
Now, this is Ann Taylor's response, and I've seen Twitter sort of a flutter about this. Apparently, they're very gung ho for Ann Taylor in this document, so I'm sort of anxious to see what she has to say. Comes now Bryan C. Kohberger, by and through his counsel of record, and hereby submits his reply in support of motion to rescind order issued by this court on March 22nd, 2024, without providing procedural due process. The state's objection and declaration to defendant's motion to rescind the order of the court filed March 22nd, 2024, confirms it knew by March 8th, 2024 of the survey. The state knew by March 11th, 2024, the survey was being conducted by a legitimate company. By March 21st, 2024, the defense had explained basis and validity of the survey, yet Friday afternoon, the state filed a motion alleging violation of the revised non-dissemination order, which is what the whole point was. They talked about it. They knew it was from a legitimate company. They said they were going to talk about it all together in chambers. And then the state went and did something behind the defense's back that was not originally in their agreements. This was the first mention the state made of such an allegation. The afternoon filing on March 22nd, 2024 was done with the intention of obtaining an immediate order without a hearing. Of note, due to the bias and interconnectivity in Latah County, citizens called police and the prosecutor about the survey. The ability of a prosecutor to have an order signed by a judge within the same building within a few hours of the filing, and a specific fear the defense had articulated to the state during the March 21st, 2024 meeting is evidence of the state's intention to facilitate a due process violation. Yeah, because they filed this thing at the very end of the day, and somehow there was still enough time for Judge to go in and sign off on every little thing that the state filed. Just like that. I'd be questioning that too. The Fourth Amendment of the United States Constitution and Article 1, Section 13 of the Idaho State Constitution protect Mr. Kohberger's rights. He is entitled to meaningful notice and a meaningful opportunity to be heard, which is what was supposed to happen with the in-chambers thing that was the original agreement. That did not happen here. The state points the court to State versus Head from 2023 for the proposition that since Mr. Kohberger had received a copy of the state's pleadings and responded with an objection and request to provide further briefing to the court, Mr. Kohberger received due process. In Head, the defendant was given multiple hearings in 90 days to respond to a civil proceeding. Reference to Head illustrates the significance of the constitutional deprivation for Mr. Kohberger. Even more significant is the case of Nye versus Katsilametis. I'm going to assume from 2019. It then states the due process clause of the 14th Amendment prohibits deprivation of life, liberty, or property without fundamental fairness through governmental conduct that offends the community's sense of justice, decency, and fair play. Procedural due process is the aspect of due process relating to the minimal requirements of notice and a hearing if the deprivation of a significant life, liberty, or property interest may occur. Mr. Kohberger's life and liberty are at stake. This is a capital case, and he is entitled to be heard on motions pending before this court. Halting preparations for his motion for change of venue denies his constitutional right to a fair trial. I don't disagree. I don't disagree. I'm really just hella curious as to what about this survey is making the state so nervous, because that's really sort of like that's really the only kind of like vibe I'm getting from this, is that them doing this and the questions being asked is making the state nervous for some reason. The survey work is complete for Latah County, and it shows that the jury pool in Latah County is biased. The state's action that resulted in the cessation of the surveys prevent other county comparisons. The order should be reversed. Now and in the future, no court order should be entered without procedural due process unless the parties so stipulate. And see, we heard that in the documents before, that only Latah County, like the 400 that were chosen in Latah County, that entire process was done. But in order to compare and contrast, they have to go out and do the same thing for other counties. And they can't, because now this has happened. Now, it's interesting that they're straight up saying Latah's bias. Latah is biased as shit, and we're going to end up having to prove that Latah is biased. I mean, I guess they can, just based off of the survey answers themselves. And I'm going to assume that they actually did record all of these calls, because they can't just say, oh, this person said this and this person said that. Like, they have to have the proof of it, you know? That was a lot, you guys. This is going to be a freaking long one, way longer than I thought it was going to be, but there was a lot here. You know, the way that they're sealing everything up, it wouldn't surprise me if they did not live stream this one. But we'll see. Let me know what you guys think in the comments about all of this. Who's telling the truth here? Is the defense being honest whenever they claim that the questions are literally based on like social media rumor? Or do you think that the state's being more honest and stating, yeah, no, these questions are like true case fact, and the defense is violating the gag order by doing this survey, even though these surveys are totally typical and totally normal? What do you guys think about all of this? Let me know. If you guys like the way that I present this information and give my opinion, please do not forget to leave a like on your way out and subscribe to the channel if you are not subscribed already. See y'all.